The plurality opinion explicitly said the parties are free to litigate the correct standard. So if the standard is at issue, what is your argument for rational basis versus undue burden?
To the question of what the standard should be under Iowa law, it's a very straightforward analysis, and the answer is that the test has to be rational basis analysis. As this court has said in cases like King and Sanchez, the test under Iowa law, King, Sanchez, and Searing, the test under Iowa law is a two-stage analysis. The first stage is determining the nature of the substantive due process right that's being alleged, whether or not it's fundamental. This court answered that question in PPH 4 just last year and said the alleged right is not fundamental. The second part of that analysis, if the right is fundamental, strict scrutiny applies. If the right is not fundamental, rational basis review applies. So we're on the merits, we're simply asking this court to complete that second part of the two-stage analysis. The only option available to the court is rational basis analysis.
Paths you started to outline before we interrupted.
Path is the one that we advocated for in the district court, and so that would mean holding that the district court erred by not further litigating that question of what standards should apply. We think that question was an open question for the district court to litigate. We think, especially post Dobbs, the PPH 1 majority opinion's reliance on the alleged concession by the state there that the state right is coextensive with the federal right, and therefore the court applied undue burden analysis. Once there is no undue burden test under the federal Constitution, any weight to be given to that concession would actually lead to the opposite conclusion, that now that rational basis review is applied under the federal Constitution, rational basis review has to be the test under the state Constitution. But we're not asking the court to rely on that alleged concession. We're just saying under that first path, the question was an open question the district court could have resolved. The court erred by not resolving it.
You say that there's no ground in between strict scrutiny, fundamental right on the one hand, and rational basis on the other. Wasn't there in this country sort of an intermediate standard under, at least as to the federal right, at least between Casey and Dobbs?
Intermediate standard, but that standard was based on the premise that the abortion right was a fundamental right. So in Your Honor's majority opinion just last year in PPH 4, Your Honor walked through some of the other substantive due process contexts, including a right to procreate, a right to family creation, et cetera, and said in those contexts, we've done something that looks more like an intermediate type of scrutiny, but in each of those cases, in reading the majority opinion there, each of those cases that intermediate level of scrutiny was premised on the existence of a fundamental right. So yes, when there's a fundamental right at stake, the court has applied some different type of analysis, but there is no fundamental right here, and when there is no fundamental right at stake, the test has to be rational basis.
You about what I wrote, but I will. I think every time I said we're not recognizing anymore what we said in Planned Parenthood 2, that it's a fundamental right subject to strict scrutiny. I think I always tied those two phrases together. It was the strict scrutiny part that I thought we were overruling in Planned Parenthood 4.
We read the court to be doing both, and I don't want to argue about what Your Honor wrote either in PPH 4, but we read the court to be doing both. The test and the analysis that this court walked through is the same analysis that the U.S. Supreme Court applies in determining whether or not a fundamental right exists. Is it deeply rooted in the nation's history and tradition, or in the text of the Constitution? The answer to that question this court reached in PPH 4 was clearly no. And so if there's not a fundamental right, the only option available is the rational basis test. Now again, we're not contending that the PPH 4 plurality decided that rational basis review is the test. We just read the court's language saying there is no fundamental right, subjecting the analysis to strict scrutiny, to mean that the plurality was simply not going to decide what the test was.
To sort of the first area